Series of constitution. Now I am talking about fundamental rights and fundamental duties. The constitution of England is unwritten, hence there is in England no code of fundamental rights as exists in the constitution of the United States or in other written constitution of the world. This does not mean, however, that in England there is no recognition of the fundamental of the individual without which democracy becomes, without which this is not mean, however, that in England there is no recognition of those basic rights of the individual without which democracy becomes meaningless. The object, in fact, is secured here in a different way. The foundation of the individual rights in England may be said to be negative in the sense that an individual has the right and freedom to take whatever action he likes so long as he does not violate any rule of the ordinary law of the land. Individual liberty is secured by judicial decisions determining the rights of individuals in particular cases brought before the courts. The judiciary is the guardian of individual rights in England as elsewhere, but there is a fundamental difference. While in England the courts have the fullest power to protect the individual against executive tyranny, the courts are powerless as against legislative aggression upon individual rights. In short, there is no fundamental rights binding upon the legislature in England. The English Parliament being theoretically omnipotent, there is no law which it cannot change. As has been already said, the individuals has rights, but they are found on the ordinary law of the land, which can be changed by parliament like other laws. So there is no right which may be said to be fundamental in the strict sense of the term. Another vital consequence of the supremacy of parliament is that the English court has no power of judicial review over legislation at all. It cannot declare any law as unconstitutional on the ground of contravention of any supposed fundamental or natural rights. The fundamental difference in approach to the question of individual rights between England and the United States is that while the English were anxious to protect individual rights from the abuses of executive power, the framers of the American Constitution were apprehensive of tyranny not only from the executive but also from the legislature. That is a body of men who for the time being form the majority in the legislature. So the American Bill of Rights contained in the first 10 amendments of the Constitution of the USA is equally binding upon the legislature as upon the executive. The result has been the establishment in the United States of the judicial supremacy as opposed to the parliamentary supremacy in England. The courts in the United States are competent to declare an act of Congress as unconstitutional on the ground of contravention of any provision of the Bill of Rights. Further, it is beyond the competence of the legislature to modify or adjust any of the fundamental rights in view of any emergency or danger to the state. That power has been assumed by the judiciary in the United States. In India, the Simon Commission and the Joint Parliamentary Committee, which were responsible for the Government of India Act 1935, had rejected the idea of enacting declarations of fundamental rights on the ground that abstract declarations are useless unless there exists the will and the means to make them effective. But nationalist opinion since the time of the Nehru report was definitely in favor of the Bill of Rights, because the experience gathered from the British regime was that a subservient legislature might serve as a handmaid to to the executive in committing inroads upon individual liberty, regardless of the British opinion. Therefore, the makers of our Constitution adopted fundamental rights to safeguard individual liberty and also for ensuring, together with the directive principles, social, economic, and political justice for every member of the community, that they have succeeded in this venture in the testimony of an ardent observer of the Indian Constitution. In India, it appears that fundamental rights have both created a new equality and have helped to preserve individual liberty. The number of the rights cases brought before high courts and the Supreme Court attest to the value of the rights, and the frequent use of prerogative writs testifies to their popular acceptance as well. The classic arguments against the inclusion of written rights in a constitution have not been borne out in India. In fact, the reverse may have been the case. So the Constitution of India has embodied a number of fundamental rights in Part 3 of the Constitution, which are subject to the exceptions to be mentioned thereafter, to act as limitations not only upon the powers of the executive but also upon the powers of legislature. Though the model has been taken from the Constitution of the United States, the Indian Constitution does not go so far, the rather affects the compromise between the doctrines of parliamentary sovereignty and judicial supremacy. On the other hand, the Parliament of India cannot be said to be sovereign in the English sense of legal omnipotence, for the very fact that the Parliament is created and limited by the written Constitution enables our Parliament to legislate only subject to the limitations and prohibitions imposed by the Constitution, such as the fundamental rights, the distribution of legislative powers, etc. In case any of these limitations are transgressed, the Supreme Court and the High Courts are competent to declare a law as unconstitutional and void. So far as the contravention of fundamental rights is concerned, this duty is specially enjoined upon the courts by the Constitution. Article 13, by way of abundant caution, Clause 2 of Article 13 says, the state shall not make any law which takes away or abuses the rights conferred by this part, and any law made the contravention of this clause shall, to the extent of the contravention, be void. To this extent, our Constitution follows the American model rather than English. The powers of the judiciary vis-a-vis the legislature are weaker in India than in the United States in two respects. Firstly, fundamental rights under Indian Constitution distinguished from American Bill of Rights. Firstly, while the declaration of the American Bill of Rights are absolute and the power of the state to impose restrictions upon the fundamental rights of the individual in the collective interests had to be evolved by the judiciary. In India, this power has been expressly conferred upon the legislatures by the Constitution itself. In the case of the major fundamental rights, of course, leaving a power of judicial review in the hands of the judiciary to determine the reasonableness of the restrictions imposed by the legislature. 44th Amendment 1978, the right to property. Secondly, by somewhat hasty step, the Janata government headed by Morarji Desai had taken out an important fundamental right, namely the right of property, by omitting Article 19(1)(f) and 31 by the 44th Amendment Act 1978. Of course, the provision in the same amendment being transposed to a new been transposed to a new article 300A, which is outside part 3 of the constitution and has been labeled at chapter 4 of part 12, which deals with finance, property, contracts and suits. But this is not a fundamental right. While under the Congress rule for 30 years, the ambit of fundamental rights embodied in part 3 of the original constitution had been circumscribed by multiple amendments. Bit by bit, the death blow to one of the fundamental rights came from the Janata government. The net result of the foregoing amendments inflicted upon the right to property are the right not to be deprived of one's property save by authority of law is no longer a fundamental right. Hence, if anybody's property is taken away by exhaustive fiat without the authority of law or in contravention of a law, the aggrieved individual shall have no right to move the Supreme Court under Article 32. If a legislature makes a law depriving a person of his property, he cannot challenge the reasonableness of the restriction imposed by such law, invoking Article 19(1)(f), because that provision has ceased to exist. Since Clause 2 of Article 31 has vanished, the individual's right to property is no longer a guarantee against the legislature in respect of any compensation for loss of such property. Article 31(2) in the original constitution embodied the principle that if the state makes a compulsory acquisition or requisitioning of private property, it must make a law. B, such law must be for the public purpose, and C, some compensation must be paid to the expropriated owner. Of course, by the 25th Amendment of 1971, during the regime of Mrs. Gandhi, the requirement of compensation was replaced by an amount, the adequacy of which could no longer be challenged before the courts. Nevertheless, the Supreme Court held the aggrieved individual might complain if the amount so offered was illusory or amounted to confiscation, but even such an innocuous possibility has been foreclosed by the 44th Amendment. The short argument advanced in the statements of objects and reasons of the 45th Amendment for deleting the fundamental right to property is that it was only being converted into a legal right. What is meant is that while Article 19(1)(f) and 31(2) of the original Constitution operated as limitations on the legislature itself, the 45th Amendment will installs the legislature as a guardian of the individual's right to property without any fetter on its goodwill and wisdom. But if the legislature could be presumed to be infallible and innocent, this would be a good argument for omitting all the fundamental rights from Part 3. As it has been pointed out earlier, the very justification of putting limitations on the legislature by adopting a guarantee of fundamental rights is that history has proved that the group of human beings constituting for the time being the majority in a legislative body are not always infallible, and that is why the constitutional safeguards are necessary to permanently protect the individual from legislative tyranny. Thirdly, by subsequent amendments, the arena of fundamental rights has been narrowed down by introducing certain exceptions to the operation of fundamental rights, namely Article 31A, 31B, 31C, and 31D. Of these articles, 31A, 31C are exceptions to the fundamental rights enumerated in Article 14 and 19. This means that any law falling under the ambit of Article 31A, as for example, a law for agrarian reform, or Article 31C, a law for the implementation of any of the directive principles contained in Part 4 of the Constitution, cannot be invalidated by any court on the ground that it contravenes any of the fundamental rights guaranteed by Article 14, equality before law, Article 19, freedom of expression, assembly, etc. Article 31B, however, offers almost complete exception to all the fundamental rights enumerated in Part 3 if any enactment is included in 9th schedule, which is to be read along with Article 31B, then such enactment shall be immune from constitutional invalidity on the ground of contravention of any of the fundamental rights, but shall be open to challenge on the ground of damage to the basic structure of the Constitution subsequent to 24/4/1973, that is the date of decision of Keshavanand's case. Fourthly, by the 42nd Amendment Act 1976, a contravening factor has been introduced, namely the fundamental duties mentioned in Article 51A, though these duties are not themselves enforceable in the courts nor their violation as such punishable. Nevertheless, if a court before which a fundamental right is sought to be enforced has to read all parts of the Constitution, it may refuse to enforce a fundamental right at the instance of an individual who has patently violated any of the duties specified in Article 51A. If so, the emphasis of the original Constitution on fundamental rights has been minimized. Fifthly, the correct category of the fundamental rights under our Constitution is exhaustively enumerated in Part 3 of the Constitution, and American Constitution 9th Amendment expressly says that the enumeration of certain rights in the Bill of Rights shall not be construed to deny or disparage other retained by the people. This rests on the theory of inalienable natural rights, which can by no means be lost to the individual in a free society. The guarantee of some of them in the written Constitution cannot therefore render obsolete any right which inhered in the individual even before the Constitution, as for example the right to engage in political activity, but there is no such unenumerated right under our Constitution. As was observed in the early case of Gopalan versus state of Maharashtra, the legislatures under our Constitution being sovereign except in so far as their sovereignty has been limited by the Constitution, either expressly or by necessary implication, the courts cannot impose any limitation upon the sovereignty either on the theory of the spirit of Constitution or of that of natural rights, that is, rights other than those which are enumerated in Part 3 of the Constitution. Any expansion of the fundamental rights under the Indian Constitution must therefore rest on judicial interpretation, and the Supreme Court has gone ahead in this direction by enlarging the scope of Article 21. It should not be supposed, however, that there is no other justiciable right provided by our Constitution outside Part 3. Limitations upon the state are imposed by other provisions of the Constitution, and these limitations give rise to corresponding rights to the individual to enforce them in a court of law if the executive or the legislature violates any of them. Thus, Article 265 says that no tax shall be levied or collected except by the authority of law. This provision confers a right upon an individual not to be subjected to arbitrary taxation by the executive, and if the executive seeks to levy a tax without legislative sanction, the aggrieved individual may have his remedy from the courts. The new provision in Article 300A belongs to this category. Similarly, Article 301 says that subject to the provisions of this part, trade, commerce and intercourse throughout the territory of India shall be free. If the legislature or the executive imposes any restriction upon the freedom of trade or intercourse which is not justified by the other provisions of Part 13 of the Constitution, the individual who is affected by such restriction may challenge the action by appropriate legal proceeding. When then is the distinction between the fundamental rights included in Part 3 of the Constitution and those rights arising out of the limitations contained in the other parts which are equally justiciable? Though the rights of both these classes are equally justiciable, the constitutional remedy by the way of an application direct to the Supreme Court under the Article 32, which is itself included in Part 3 as a fundamental right, is available only in the case of fundamental rights. If the right follows from some other provisions of the Constitution, say Article 265 or Article 301, the aggrieved person may have his relief by an ordinary suit or by an application under Article 226 to the High Court. But an application under Article 32 shall not lie unless the invasion of the non-fundamental right invokes the violation of some fundamental rights as well. As the word fundamental suggests, under some constitution, fundamental rights are immune from constitutional amendments. In other words, they are conferred a special sanctity as compared with other provisions of the Constitution. But this principle has been rejected by the Indian Constitution as it stands interpreted by amendments of the Constitution themselves and judicial decisions. Of course, no part of the Constitution of India can be changed by ordinary legislation unless so authorized by the Constitution itself, as for example Article 4. But all parts of the Constitution except the basic feature can be amended by the Amendment Act passed under Article 368, including the fundamental rights. This proposition has been established after a history of its own. Until the case of Golaknath, the Supreme Court has been holding that no part of our Constitution was unamendable and that Parliament might, by passing a Constitution Amendment Act in accordance with the requirements of Article 368, amend any provision of the Constitution, including the fundamental rights and Article 368 itself. According to this earlier view, thus the court could act as a guardian of the fundamental rights only so long as they were not amended by the Parliament of India by the required majority of the votes. In fact, some of the amendments of the Constitution so far made were effected with a view to suppress superseding judicial pronouncements which had invalidated social or economic legislation on the ground of contravention of fundamental rights. Thus, the narrow interpretation of Clause 2 of Article 19 by the Supreme Court in the cases of Ramesh Thapar versus State of Madras and Brijbhushan versus State of Delhi was superseded by the Constitution First Amendment Act 1951, while the interpretation given to Article 31 in the cases of State of West Bengal versus Gopal, Dwarika Das versus Solapur Spinning Company and State of West Bengal versus Bela Banerjee was superseded by the Constitution Fourth Amendment Act 1955. But the Supreme Court cried halt to the process of amending the fundamental rights through the amending procedure laid down in Article 368 of the Constitution by its much debated decision in Golaknath versus State of Punjab. In this case, overruling its two earlier decisions, the Supreme Court held the fundamental rights embodied in Part 3 has been given a transcendental position by the Constitution, so that no authority functioning under the Constitution, including Parliament Parliament exercising the amending power under Article 368 was competent to amend the fundamental rights. C. But by the 24th Amendment Act 1971, Article 13 and Article 68 were amended to make it clear that fundamental rights were amendable under the procedure laid down in Article 368, thus overriding the majority decision of the Supreme Court in Golaknath versus State of Punjab. The majority decision in Keswanand Bharati case upheld the validity of these amendments and also overruled Golaknath's case, holding that it is competent for Parliament to amend fundamental rights under Article 368, which does not make any exception in favor of the fundamental rights, nor does 13 comprehend acts amending the Constitution itself. At the same time, Keswananda's case also laid down that there were implied limitations on the power to amend, and that power cannot be used to alter the basic feature of the Constitution. A big limitation that stands in the way of Parliament acting by a special majority to introduce drastic changes in the Constitution is the judicially innovated doctrine of basic features, which can be eliminated only if a bench larger than the 13-judge bench of in Keswanand's case be prepared to overturn the decision in that case. In the meantime, applying Keswanand's, the majority of the Constitution bench has invalidated clause 4 and 5 of Article 368 as violative of the basic features of the Constitution. Minerville versus Union of India, 1980 Supreme Court 1789, para 21 and 28. The provisions of Part 3 of our Constitution, which enumerate the fundamental rights, are more elaborate than those of any other existing written constitution relating to fundamental rights and cover a wide range of topics. The Constitution itself classifies the fundamental rights under 7 groups as follows: right to equality, right to particular freedoms, right against exploitation, right to freedom of relation, cultural and educational rights, right to property, right to constitutional remedies. Of these, the right to property has been eliminated by 44th Amendment Act, so that only 6 freedoms now remain in Article 19(1). The rights falling under each of the 6 categories are shown in the Table 5. Another classification which is obvious is from the point of view of persons to whom they are available. Thus, some of the fundamental rights are granted only to citizens. First, protection from discrimination on ground only of religion, race, caste, sex, or place of birth. Article 15. Equality of opportunity in matters of public employment. Article 16. Freedoms of speech, assembly, association, movement, residence, and profession. Article 19. Cultural and educational rights of minorities. Article 30. Some of the fundamental rights, on the other hand, are available to any person on the soil of India, citizen or foreigner. Equality before the law and equal protection of the law. Article 14. Protection in respect of conviction against ex post facto laws, double punishment and self-incrimination. Article 20. Protection of life and personal liberty against action without authority of law. Article 21. Right against exploitation. Article 23. Freedom of relation. Article 25. Freedom as to payment of taxes for the promotion of any particular religion. Article 27. Freedom as taxes for the freedom as to attendance at religious instruction or worship in state educational institution. Article 28. Some of the fundamental rights are negatively worded provided as prohibition to the state, as for example, Article 14 says, the state shall not deny to any person equality before the law. Similar are the provisions of Article 15(1), 16(2), 18(1), 20, 22(1), 28(1). There are others which positively confer some benefits upon the individual, as for example the right to religious freedom under Article 25 and the cultural and educational rights under Article 29, 131. Still another classification may be made from the standpoint of the extent of limitation imposed by the different fundamental rights upon legislative power. On the one hand, we have some fundamental rights such as under Article 21, which are addressed against the executive but impose no limitation upon the legislature at all. Thus, Article 21 simply says that no person shall be deprived of his life or personal liberty except according to the procedure established by law. It was early held by our Supreme Court that a competent legislature is entitled to lay down any procedure for the deprivation of personal liberty, and that the courts cannot interfere with such law on the ground that it is unjust, unfair, and unreasonable. In this view, the object of Article 21 is not to impose any limitation upon the legislative power, but only to ensure that the executive does not take away a man's liberty except under the authority of a valid law, and in strict conformity with the procedure laid down by such law. In later case, however, the Supreme Court has found it difficult to immunize laws made under Article 21 from the attack on the ground of unreasonableness under the relevant clauses of Article 19(1) or Article 14, and recent Supreme Court decisions show an increasing inclination in that direction. To the other extreme are fundamental rights which are intended as absolute limitations upon the legislative power, so that it is not open to the legislature to regulate the exercise of such rights, as for example the rights guaranteed by Article 15, 17, 18, 20, 24. In between the two classes stand the rights guaranteed by Article 19, which itself empowers the legislature to impose reasonable restrictions upon the exercise of these rights in the public interest. Though the individual rights guaranteed by Article 19 are in general binding upon both the executive and the legislature, these authorities are permitted by the Constitution to make valid exceptions to the rights within limits imposed by the Constitution. Such grounds in brief are security of the state, public order, public morality, and the like. All the above rights are available against the state. It is now settled that the rights which are guaranteed by Article 19 and 21 are guaranteed against state action, as distinguished from violation of such rights by private individuals. In the case of violation of such rights by individuals, the ordinary legal remedies may be available, but not the constitutional remedies. State action in this context must, however, be understood in a wider sense, for interpreting the word state wherever it occurs in the part on fundamental rights. A definition has been given in Article 12, which says that unless the context otherwise requires, the state will include not only the executive and legislative organs of the union and state, but also local bodies such as municipal authorities as well as other authorities. This latter expression refers to any authority or body of persons exercising the power to issue orders, rules, bylaws, or regulation having the force of law. As for example, a board having the power to issue statutory rules for exercising governmental powers, even the fact of a private individual may become an act of the state if it is enforced or aided by any of the authorities just referred to. It should be noted, however, that there are certain rights included in Part 3 which are available not only against the state but also against private individuals. For example, Article 51, Clause 2, equality in regard to access to and use of places of public resort. Article 17, prohibition of untouchability. Article 18, 3 to 4, prohibition of acceptance of foreign title. Article 23, prohibition of traffic in human beings. Article 24, prohibition of employment of children in hazardous employment. But these provisions in Part 3 are not self-executory. That is to say, these articles are not directly enforceable. They would be indirectly enforceable. Only if some law is made to give effect to them and such law is violated, it follows that classification of fundamental rights, not executory and self-executory, is another possible mode of classification. We may now proceed to a survey of the various fundamental rights. In particular, Article 14 of the Constitution provides the state shall not deny to any person equality before the law or the equal protection of laws within the territory of India. We must know about the Article 14 of our Constitution, which provides the state shall not deny to any person equality before the law or the equal protection of laws within the territory of India. This is very important. Prima facie, the expression equality before the law and equal protection of the laws may seem to be identical, but in fact they mean different things. While equality before the law is a somewhat negative concept, implying the absence of any special privilege by reason of birth, creed, or the like in favor of any individual, and the equal subjection of all classes to the ordinary law. Equal protection of law is more positive concept, implying the right to equality of treatment in equal circumstances. The concept of equality and equal protection of laws in its proper spectrum encompasses social and economic justice in a political democracy. Equality before law, as a student of English constitutional law knows, it is the second corollary from Dicey's concept of the rule of law. Equality before law is correlative to the concept of rule of law for all-round evaluation of healthy social order. It means that no man is above the law of the land and that every person, whatever be his rank or status, is subject to the ordinary law and amenable to the jurisdiction of any ordinary tribunal. Against every citizen, from the Prime Minister down the humblest peasant, is under the same responsibility for every act done by him without lawful justification, and in this respect there is no distinction between officials and private citizens. It follows that the position will be the same in India. But even in England, certain exceptions are recognized to the above rule of equality in the public interest. The exceptions allowed by the Indian Constitution are the President or the Governor of the state shall not be answerable to any court for the exercise and performance of the powers and duties of his office, or for any act done or purporting to be done by him in the exercise and performance of those powers and duties. No criminal proceeding whatsoever shall be instituted or continued against the President president or a governor in any court during his term of office. No civil proceeding in which relief is claimed against the president or the governor of the state shall be instituted during his term of office in any court in respect of any act done or purporting to be done by him in his personal capacity, whether before or after he entered upon his office as president or governor of such state, until the expiration of 2 months next after notice in writing has been delivered to the president or the governor, as the case may be, or left at his office, stating the nature of proceedings, the cause of action, therefore, the name, description, any place of residence of the party by whom such proceedings are to be instituted, and the relief which he claims. Article 361. The above immunities, however, shall not bar the impeachment proceeding against the president, suits or other appropriate proceedings against the governor of India or the governor of a state. Besides the above constitutional exceptions, there will of course remain the exceptions acknowledged by the Committee of Nations in every civilized country, as for example, in favor of foreign sovereigns and ambassadors, equal protection of laws. Equal protection of laws, on the other hand, would mean that among equals the law should be equal and equally administered, that like should be treated like. Equal protection requires affirmative action by the state towards unequals by providing facilities and opportunities. In other words, it means that right to equal treatment in similar circumstances, both in the privileges conferred and in liabilities imposed by the law. None should be favored and none should be placed under any disadvantage in circumstances that do not admit of any reasonable justification for a different treatment. Thus, it does not mean that every person shall be taxed equally, but the persons under the same character should be taxed by the same standard. But if there is any reasonable basis for classification, the legislature would be entitled to make a different treatment. The legislature is competent to exercise its discretion and make classification. It is for the legislature to identify the class of the people to be given protection and on what basis such protection was to be given. The court cannot interfere. A state has wide discretion in respect of the classification of objects, persons and things for the purposes of taxation. The legislature can devise classes for the purpose of taxing or not taxing, exempting or not exempting, granting incentives and prescribing rate of tax, benefits and concessions. Thus, it may first exempt certain classes of property from taxation at all, such as charities, libraries, and like. Impose different specific taxes upon different trades and professions, tax real and personal property in different manner, and so on. The guarantee of equal protection thus is a guarantee of equal treatment of persons in equal circumstances, permitting differentiation in different circumstances. In other words, the principle of equality does not mean that every law must have universal application for all persons who are not by nature, attainment or circumstance in the same position, as the varying needs of different classes of persons often require separate treatment. The principle does not take away from the state the power of classifying persons for legitimate purposes. A legislature which has to deal with diverse problems arising out of an infinite variety of human relations must of necessity have the power of making special laws to attain particular objects, and for that purpose it must have large powers of selection or classification of persons and things upon which such law are to operate. In order to be reasonable, a classification must not be arbitrary but must be rational. That is to say, it must not only be based on some qualities or characteristics which are to be found in all the persons grouped together and not in odd others who are left out, but those qualities or characteristics must have a reasonable relation to the object of legislation. The reasonableness of a provision depends upon the circumstances obtaining a particular time and the urgency of the evil sought to be controlled. The possibility of the power being abused is no ground for declaring a provision violative of Article 14. In order to pass the test, two conditions must be fulfilled, namely that first, classification must be founded on an intelligible differentia which distinguishes those that are grouped together from others, and second, that differentia must have a rational relation to the object sought to be achieved by the act. It is not possible to exhaust the circumstances or criteria which may accord a reasonable basis for classification in all cases. It depends on the sub-object of the legislation in view, and whatever has a reasonable relation to the object or purpose of the legislation is a reasonable basis for classification of the persons or things coming under the purview of the enactment. Thus, the basis of classification may be geographical. The classification may be according to difference in time. The classification may be based on the difference in the matter of the trade, calling, or occupation which is sought to be regulated by the legislation. Similarly, higher educational qualification is a permissible basis of classification for promotion, as it has nexus with higher efficiency on the promotional post. Thus, it has been held that in offences relating to women, adultery, women in India may be placed in a more favorable position having regard to their social status and need for protection. In the law of prohibition, it would not be unconstitutional to differentiate between civil and military personnel or between foreign visitors and Indian citizens, for they are not similarly circumstanced from the standpoint of need for prohibition of consumption of liquor. Exemption to the candidate who stood first in the Forest Rangers College from selection as assistant conservator by the Public Service Commission, it being based on reasonable qualification, it not ultra vires Article 14. The guarantee of equal protection applies against substantive as well as procedural laws. The decision-making process should be transparent, fair, and open. The procedure for distribution of state largesses must be transparent, just, fair, and non-arbitrary. Non-transparency promotes nepotism and arbitrariness. Hence, the discretion vested by the statute is to be exercised fairly and judicially and not arbitrarily, but subject to the requirements of law. In the absence of rules, the action of government is required to be fair and reasonable. From the standpoint of the latter, it means that all litigants who are similarly situated are able to avail themselves of the same procedural rights for relief and for defense without discrimination discrimination. Of course, if the differences are of a minor or of unsubstantial character which have not prejudiced the interest of the person or persons affected, there would not be a denial of equal protection. Again, a procedure different from that laid down by the ordinary law can be prescribed for the particular class of persons if the discrimination is based upon the reasonable classification having regard to the object which the legislation has in view and the policy underlying it. Thus, in a law which provides for the externment of undesirable persons who are likely to jeopardize the peace of the locality, it is not an unreasonable discrimination to provide that a suspected person shall have no right to cross-examine the witness who depose against her, for the very object of the legislation, which is an extraordinary one, would be defeated if such a right were given to the suspected person. In the reference on the Special Courts Bill 1978, the Supreme Court has held that the setting up of a special court for the expeditious trial of offences committed during the emergency period from 25/6/1975 to 27/3/1977 by high public officials in view of the congestion of work in the ordinary criminal courts and in view of the need for a speedy termination of such prosecutions in the interest of the functioning of democracy under the Constitution of India as a reasonable classification. But to include in bill any offence committed during any period prior to the proclamation of emergency in June 1975 was unconstitutional inasmuch as such classification has no reasonable nexus with the object of the bill. The guarantee of the equal protection includes absence of any arbitrary discrimination by the laws themselves or in the matter of their administration. Thus, even where a statute itself is not discriminatory, but the public official entrusted with the duty of carrying it into operation applies to against an individual, not for the purpose of the act but intentionally for the purpose of injuring him. The latter may have that executive act annulled by the court on the ground of contravention of the guarantee of equal protection. Of course, it is for the aggrieved individual to establish beyond doubt that the law was applied against him by the public authority with an evil eyes and an unequal hand. In short, Article 14 hits arbitrariness of state action in any form. An act which is discriminatory is liable to be labeled as arbitrary. The court will not interfere in the policy decisions of the government unless the government action is arbitrary or indivisible discriminatory. The government policy is not subject to judicial review unless it is demonstrably arbitrary, capricious, irrational, discriminatory, or violative of constitutional or statutory provisions. In the duty of a state to allay fears of citizens regarding discrimination and arbitrariness, however, protective discrimination in favor of Supreme Courts and in favor of scheduled castes and scheduled tribes is a part of constitutional scheme of social and economic justice to integrate them into the national mainstream so as to establish an integrated social order with equal dignity of persons. Relation between Article 14 to 16, as the Supreme Court has observed, Articles 14 to 16 taken together enshrine the principle of equality and absence of discrimination. While the principle is generally stated in Article 14, which extends to all persons, citizens or aliens since Article 15 and 16 deal with particular aspect of that equality. Thus, Article 15 is available to citizens only, and it prohibits discrimination against any citizen in any matter at the disposal of the state or any of the specified grounds, namely religion, race, caste, sex, or place of birth. Article 16 is not confined to citizens, but it is restricted to one aspect of public discrimination, namely employment under the state. In matters not coming under Article 15 and 16, if there is any discrimination or validity of that can be challenged under the general provision in Article 14. As just stated, a particular aspect of the equality guaranteed by Article 14 is the prohibition against discrimination contained in Article 15 of the Constitution, which runs thus. The state shall not discriminate against any citizen on ground only of religion, race, caste, sex, place of birth, or any of them. No citizen shall on ground only of religion, race, caste, sex, place of birth of any of them, subject to any disability, liability, restriction, or condition with regard to access to shops, public restaurants, hotels, and places of public entertainment, or the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public. Nothing in this article shall prevent the state from making any special provision for women and children. Nothing in this article in clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and the scheduled tribes. It will be seen that the scope of this article is very wide. While the prohibition in clause 1 is labeled against state action, the prohibition in clause 2 is labeled against individuals as well. Clause 1 says that any act of state, whether political, civil, or otherwise, shall not discriminate as between citizens on grounds only of religion, race, caste, sex, place of birth, or any of them. The plain meaning of this prohibition is that no person of a particular religion, caste, etc. shall be treated unfavorably by the state when compared with persons of any other religion or caste merely on the ground that he belongs to the particular religion or caste, etc. The significance of the word only is that if there is any other ground or consideration for the differential treatment besides those prohibited by this article, the discrimination will not be unconstitutional. Thus, discrimination in favor of a particular sex will be permissible if the classification is the result of other consideration besides the fact that the persons belong to that sex, as for example physical or intellectual fitness for some work. For instance, women may be considered to be better fitted for the jobs of a nurse, while they may not be considered eligible for employment in heavy industries like steel factory. Such discrimination being based on a ground other than sex would not be considered to be unconstitutional. But if a person is sought to be discriminated against simply because he belongs to a particular community, race, or sex, he can get the state action annulled through a court. While racial discrimination still persists as a malignant growth upon Western society, it speaks volumes of Indian achievement achievement that a possible victim of racial discrimination in India can obtain relief direct from the highest court of the land by means of a petition for an appropriate writ, and yet no such complaint has so far come before the courts. As already stated, in regard to the public places specified in clause 2, the protection is available even against discriminatory act by private individuals. Clause 2 provides that so far as places of public entertainments are concerned, no person shall be subjected to discrimination on the grounds only of religion, race, caste, sex, place of birth, or any of them. Whether such discrimination is the result of an act of the state or of any other individual, even wells, tanks, bathing ghats, roads and places of public resort which are owned by private individual are subject to this prohibition, provided they are maintained wholly or partly out of the state funds, or they have been dedicated to the use of general public. The above prohibition against discrimination, however, would not preclude the state from making special provisions for women and children, making special provision for the advancement of any socially and educationally backward classes of citizens, or for the scheduled castes and scheduled tribes. These exceptional classes of people require special protection, and hence any legislation which is necessary for the making of special provisions for persons of these classes would not be held to be unconstitutional. Thus, it has been held that a section 497 of Indian Penal Code, which lays that in an offence of adultery, though the man is punishable for adultery, the woman is not punishable as an abettor, is not unconstitutional, because such immunity is necessary for the protection of women in view of their existing position in Indian society. Similarly, though discrimination on the ground of caste only is prohibited by clause 1 of the article, it would be permissible under clause 4 for the state to reserve seats for the members of the backward classes or of the scheduled caste or tribes, or to grant them fee concessions. In public educational institutions, Article 15(4) envisages the policy of compensatory or protective discrimination, but it should be reasonable and consistent with the ultimate public interest, that is national interest and the interest of community or society as a whole. But the provision cannot be justifiably invoked in a granting remission to the convicted persons belonging to the scheduled caste and scheduled tribes, as it would not be a measure to their advancement. However, the benefit obtained was permitted to be retained. It was held that an SC/ST candidate selected for admission to a course on the basis of merit as a general candidate should not be treated as a reserved candidate, and the reservation for admission to the specialties, super specialties in postgraduate and doctoral course in medicine is permissible. As a corollary from the general assurance of absence of discrimination by the state on grounds only of religion, race, caste, sex, or place of birth, Article 15, the Constitution guarantees equality of opportunity in matters of public employment. Article 16 says that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any of office under the state. No citizen shall on ground only of religion, race, caste, sex, descent, place of birth, or any of them be ineligible for any office under the state. The true import of equality of opportunity is not simply a matter of legal equality. Its existence depends not merely on the absence of disabilities, but on the presence of abilities and opportunity of excellence in each cadre grade. And equality of opportunity means equality as between the members of the state class of employees and not between that of a separate independent classes. A person cannot be excluded from a state service merely because he is a Brahmin, even though this result is reached by reason of a distribution of posts amongst communities according to a ratio or quota. Government jobs or service cannot be denied to the person suffering from AIDS. This equally is to be observed by the state not only in the matter of appointments to the public services but also in the matter of any other public employment where the relationship of master and servant exists between the state and the employees. It bars discrimination not only in the matter of initial appointment but also of promotion and termination of the service itself. And employment as employment includes promotion. This right is a safeguard not only against communal discrimination but also against local discrimination or even against discrimination against the weaker sex. The only exception to the above rule of equality are residents within the state may be laid down by Parliament as a condition for particular classes of employment of appointment under any state or other local authority. Article 16(3). By virtue of this power, Parliament enacted the Public Employment Requirement as to Residence Act 1957, empowering the Government of India to prescribe residence as condition for employment in certain posts and services in the state of Andhra Pradesh and in the Union Territories of Himachal Pradesh, Manipur and Tripura. This act having expired in 1974, there is no provision to prescribe residence as a condition for public employment, except that for Andhra Pradesh special provisions have been made by inserting a new Article 371D in the Constitution itself. The state may reserve any post or appointment in favor of any backward class of citizens who, in the opinion of state, are not adequately represented in the services under the state. Article 16(4). This is to provide socio-economic equality to the disadvantaged. Offices connected with a religious or denominated institution may be reserved for members professing the particular religion or belonging to the particular denomination to which the institution relates. Article 16(5). The claims of the members of the scheduled caste and scheduled tribes shall be taken into consideration in the matter of appointment to services and posts under the Union and the states, so far as may be consistent with the maintenance of efficiency of the administration. Article 335. But the proviso to the Article 335 providing for giving relaxation in qualifying marks in any examination or lowering the standard of evaluation in favor of the members of the SC/ST hits the consideration of maintenance of efficiency in administration and has done away with the emphasis on it laid down the apex court in some cases. The Supreme Court has held that while Article 16(4) is apparently without any limitation upon the power of the reservation conferred by it, it has to be read together with Article 335, which enjoins that in taking into consideration the claims of the member of the scheduled caste and scheduled tribes in the making of appointments in connection with the affairs of the Union or a state, the policy of the state should be consistent with the maintenance of efficiency of administration. The result is that there can be no doubt that the constitution makers assumed that while making adequate reservation under Article 16(4), care would be taken not to provide for unreasonable, excessive or extravagant reservation. Therefore, like the special provision improperly made under Article 15(4), reservation made under Article 16(4) beyond the permission and legitimate limits would be liable to be challenged challenged as a fraud on the Constitution. It is to be noted carefully that the prohibition against discrimination in the matter of public employment is attracted where the discrimination is based only on any of the grounds enumerated, namely religion, race, caste, sex, descent, place of birth or residence. It does not prevent the state, like other employers, to pick and choose from a number of candidates either for appointment or for promotion on grounds of efficiency, discipline, and the like. It is also to be noted that though reservation in favor of backward classes is permissible under clause 4 of Article 16, no such reservation is possible in favor of women, nor in any other discrimination in favor of women possible, as for example relaxation of rules of recruitment or standard of qualification or the like. For the furtherance of social equality, the Constitution provides for the abolition of the evil of untouchability, Article 17, and the prohibition of conferring titles by the state. A 9-judge bench of the Supreme Court has, in Indra Sahni's case, popularly known as the Mandal Commission case, laid down the following important points which summarize the law on the issue of reservations in government employment. For further discussion, authors shorter the Constitution 13th edition under Article 16.4. Article 16.4 is exhaustive of the provisions that can be made in favor of the backward classes in the matter of employment. Backward classes of citizens is not defined in the Constitution. There is an integral connection between caste, occupation, poverty, and social backwardness. In the Indian context, lower castes are treated as backwards. A caste may be itself constitute a class. The backward classes can be identified in Hindu society with reference to castes along with other criteria such as traditional occupation, poverty, place of residence, lack of education, etc. And in communities where caste is not recognized, the rest of the criteria would apply. The backwardness contemplated by Article 16.4 is mainly social. It need not to be both social and educational. Men's test signifies imposition of an income limit for the purpose of excluding persons from backward classes. Those whose income is above that limit are referred to as creamy layer income, or the extent of property can be taken as a measure of social advancement, and on that basis the creamy layer of a given caste can be excluded. For getting reservations, a class must be backward and should not be adequately represented in the services under the state. The reservations contemplated in Article 16.4 should not exceed 50%. The rule of 50% should be applied to each year. It cannot be related to the total strength of class, service, or cadre, etc. Reservation of posts under Article 16.4 is confined to initial appointment only and cannot extend to providing reservation in the matter of promotion. If the reservation in promotion exists, it shall continue for 5 years. 16th November 1997 by the Constitution 77th Amendment Act 1995. This limitation of time has been removed by inserting clause 4A to enable it to continue reservation in promotion for the scheduled caste and scheduled tribes. Identification of backward classes is subject to judicial review. It is to be noted that many states are attempting to surpass the 50% limit. All those cases are under the consideration of the Supreme Court. The vacancies reserved could be carried forward for a maximum period of 3 years if candidates from backward classes are not available, after which they were to lapse. By inserting clause 4B in Article 16 by the Constitution 81st Amendment Act 2000, the state has been empowered to consider such unfilled vacancies as a separate class to be filled up in any succeeding years or years. Article 17 of the Constitution says untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. Parliament is authorized to make a law prescribing the punishment for this offence under Article 35, and in exercise of this power, Parliament has enacted the Untouchability Offences Act 1955, which has been amended and renamed in 1976 as the Protection of Civil Rights Act 1955. The word untouchability has not, however, been defined either in the Constitution or in the above Act. It has been assumed that the word has a well-known connotation, primarily referring to any social practice which looks down upon certain depressed classes solely on account of their birth and disables them from having any kind of intercourse with people belonging to the so-called higher classes or castes. This act declares certain acts as offences when done on the ground of untouchability and prescribes the punishments therefore, as for example, refusing admission to any person to public institutions such as hospital, dispensary, educational institution, preventing any person from worshipping or offering prayers in any place of public worship, subjecting any person to any disability with regard to access to any shop, public restaurants, hotel, public entertainments, or with regard to the use of any reservoir, tap, or other source of water, road, cremation ground, or any other place where service are rendered to the public. The sweep of the Act has been enlarged in 1976 by including within the offence of practicing untouchability the following: insulting a member of scheduled caste on the ground of untouchability, preaching untouchability directly or indirectly, justifying untouchability on historical, philosophical, or religious grounds, or on the ground of tradition of the caste system. The penal section has been enhanced by providing that in the case of subsequent convictions, the punishment may range from 1 to 2 years imprisonment. A person convicted of the offence of untouchability shall be disqualified for election to the union or the state legislature. If member of the scheduled caste is subjected to any such disability or discrimination, the court shall presume, unless the contrary is proved, that such act was committed on the ground of untouchability. In other words, in such cases there will be a statutory presumption of an offence having been committed under this act. The prohibition of untouchability in the Constitution has thus been given a realistic and effective shape by this act. Abolition of titles. Article 18. Title is something that hangs to one's name as an appendage. During the British rule, there was a complaint from the nationalists that the power to confer titles was being abused by the government for imperialistic purposes and for corrupting public life. The Constitution seeks to prevent such abuse by prohibiting the state from conferring any title at all. It is to be noted that the ban operates only against the state. It does not prevent other public institutions such as universities to confer titles or honors by way of honoring their leaders for men of merit. The state is not debarred from awarding military or academic distinctions, even though they may be used as titles. The state is not prevented from conferring any distinction or award, say for social service, which cannot be used as a title, that is, as an appendage to one's name. Thus, the award of Bharat Ratna or Padma Vibhushan cannot be used by the recipient as a title and does not accordingly come within the constitutional provision. In 1954, Government of India introduced decorations in the form of medals for 4 categories, namely Bharat Ratna, Padma Vibhushan, Padma Bhushan, and Padma Shri. While the Bharat Ratna was to be awarded for exceptional services towards the advancement of art, literature, and science and in recognition of public service of the higher order. The others would be awarded for distinguished public service in any field, including service rendered by government servants in order of the degree of the merit of their service. Though the foregoing awards were made decorations and not intended to be used as appendage to the names of the person to whom they are awarded, there was a vehement criticism from some quarters that the introduction of these awards violated Article 18. The critics pointed out that even though they may not be used as titles, the decorations tend to make distinctions according to rank, contrary to the preamble, which promises equality of status. The critics gained strength on this point from the fact that the decorations are divided into several classes, superior and inferior, and that holders of the Bharat Ratna have been assigned a place in the warrant of procedure, ninth place, that is just below the cabinet ministers of the Union, which is usually meant for indicating the rank of the different dignitaries and high officials of the state. In the interest of discipline in the administration, the result was the creation of a rank of persons on the basis of government recognition in the same way as the conferment of nobility would have done. Another criticism which seems to be legitimate is that there is no sanction either in the constitution or in any existing law against a recipient of any such decoration appending it to his name and thus using it as a title. Any such use is obviously inconsistent with the prohibition contained in Article 18(1), but it is not made an offense either by the Constitution or by any law. The apprehensions of the critics on this point were unfortunately justified by the fact that in describing the author on the title of an issue of the Hamelin lectures, the decoration Padma Vibhushan was in fact appended as a title. The protest raised by Acharya Kripalani against the award of such decorations, which went unheeded earlier, was honored by the Janta regime 1977 by putting a stop to the practice of awarding Bharat Ratna etc. by the government. But it was restored by Mrs. Gandhi after her comeback. In this context, it is to be noted that Article 18(1) itself makes an exception in favor of granting by the state of any military or academic distinction. The matter was taken to court, and the Supreme Court has now held that non-military awards by way of recognition of merit of extraordinary work, as for example the Padma Awards, are not titles of nobility and hence do not violate Article 14 or 18, provided they are not used as titles or prefixes or suffixes to the names of the awardee. Apart from the rights flowing from the above prohibition, certain positive rights are conferred by the Constitution in order to promote the ideal of liberty held out by the preamble. The foremost amongst these are the 6 fundamental rights in the nature of freedom, which are guaranteed to the citizens by the Constitution of India, Article 19. These were popularly known as the 7 freedoms. Under our Constitution, it has already been pointed out that in the original Constitution there were 7 freedoms in Article 19(1), but that one of them, namely the right to acquire, hold or dispose of properties, has been omitted by the Constitution 44th Amendment Act 1978, leaving only 6 freedoms in this article. They are freedom of speech and expression, freedom of assembly, freedom of association, freedom of movement, freedom of residence and settlement, freedom of profession, occupation, trade and business. Article 19 forms the core of our chapter on fundamental rights. It is essential for the readers to be familiar with the text of this article as it stands amended. All citizens have the right to freedom of speech and expression, to assemble peaceably and without arms, to form associations or unions, to move freely throughout the territory of India, to reside and settle in any part of India, and to practice any profession or to carry on any occupation, trade or business. Nothing in subclause A of clause 1 affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of right conferred by the said subclause in the interests of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, poor order, public order, decency or morality, or in relation contempt of court, defamation or incitement to an offense. Nothing in subclause B of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing in the interests of the sovereignty and integrity of India or public order reasonable restrictions on the exercise of the right conferred by the said subclause. Nothing in the subclause C of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing in the interest of the sovereignty and integrity of India or public order or morality reasonable restrictions on the exercise of the right conferred by the said subclause. Nothing in the subclause D, E of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing reasonable restrictions on the exercise of any of the rights conferred by the said subclause either in the interest of the general public or for the protection of the interest of any scheduled tribes. Nothing in subclause G of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing in the interest of the general public reasonable restrictions on the exercise of the right conferred by the said subclause, and in particular nothing in the said subclause shall affect the operation of any existing law insofar as it relates to or prevent the state from making any law relating to the professional and technical qualification necessary for practicing any profession or carrying on any occupation, trade or business, or the carrying on by the state or by the corporation owned or controlled by the state of any trade, business, industry or service, whether to the exclusion complete or partial of citizen or otherwise. Absolute individual rights cannot be guaranteed by any modern state. The guarantee of each of the above rights is therefore limited by our Constitution itself by conferring upon the state a power to impose by its laws reasonable restrictions as may be necessary in the larger interests of the community. This is what is meant by saying that the Indian Constitution attempts to strike a balance between individual liberty and social control. Since the goal of our constitutional system is to establish a welfare state, the makers of the Constitution did not rest with the enumeration of uncontrolled individual rights in accordance with the philosophy of laissez-faire, but sought to ensure that where collective interests were concerned, individual liberty must yield to the common goods, but instead of leaving it to the courts to determine the grounds and exempt of permissible state regulation of individual rights as the American Constitution does, the makers of our Constitution specified the preamble limitations in clause 2 to 6 of article 19 itself. The state in this context includes not only the legislative authorities of the union and the states but also other local or statutory authorities, as for example municipalities, local boards, etc., within the territory of India or under the control of the government of India. So all of these authorities may impose restrictions upon the above freedoms, provided such restrictions are reasonable and are relatable to any of the goods of public interest as specified in clause 2 to 6 of article 19. Thus the Constitution guarantees freedom of speech and expression, but this freedom is subject to reasonable restrictions imposed by the state relating to defamation, contempt of court, decency or morality, security of the state, friendly relations with foreign state, incitement to an offense, public order, maintenance of sovereignty and integrity of India. Decency or morality is not confined to sexual morality alone. It indicates that the action must be in conformity with the current standards of behavior or propriety. Hence, seeking votes at an election on the ground of the candidate's religion in a secular state is against the norms of decency and propriety of the society. It is evident that the freedom of speech and expression cannot confer upon an individual a license to commit illegal or immoral acts or to incite others to overthrow the established government by force or unlawful means. No one can exercise his rights of speech in such a manner as to violate another man's such right. Similarly, the freedom of assembly is subject to disqualification that the assembly must be peaceable and without arms and subject to such reasonable restrictions as may be imposed by the state in the interests of the public order. In other words, the right of meeting or assembly shall not be liable to be abused so as to create public disorder or a breach of the peace or to prejudice and sovereignty or integrity of India. Again, all citizens have the right to form associations or unions, but subject to reasonable restrictions imposed by the state in the interests of public order or morality or the sovereignty or integrity of India. Thus, this freedom will not entitle any group of individuals to enter into a criminal conspiracy or to form any association dangerous to the public peace or to make illegal strikes or to commit a public disorder or to undermine the sovereignty or integrity of India. Similarly, though every citizen shall have the right to move freely throughout the territory of India or to reside and settle in any part of the country, this right shall be subject to restrictions imposed by the state in the interests of the general public or for the protection of any scheduled tribes. Again, every citizen has the right to practice any profession or to carry on any occupation, trade or business, but subject to reasonable restrictions imposed by the state in the interests of the general public and subject to any law laying down qualifications for carrying on any profession or technical occupation or enabling the state itself to carry on any trade or business to the exclusion of the citizens. Scope for judicial review. As pointed out earlier, one of the striking features of the provisions relating to fundamental rights in our Constitution is that the very declaration of the major fundamental rights is attended with certain limitations specified by the Constitution itself. In the United States, the Bill of Rights itself does not contain any such limitation to the rights of the individual guaranteed thereby, but in the enforcement of those rights, the court had to invent doctrines like like that of police power of the state to impose limitations on the rights of the individual in the interests of the community at large. But as explained above in Article 19 of our Constitution, there is distinct clause attached to each of the rights declared containing the limitations or restrictions which may be imposed by the state or the exercise of each of the rights so guaranteed. For example, while the freedom of speech and expression is guaranteed, an individual cannot use this freedom to defame another, which constitutes an offense under the law. A law which may be made by the state under any of the specified grounds, such as public order, defamation, contempt of court, cannot be challenged as unconstitutional or inconsistent with the guarantee of freedom of expression, except where the restrictions imposed by the law can be held to be unreasonable by a court of law. That is how the competing interests of individual liberty and of public welfare have been sought to be reconciled by the framers of our Constitution, as Justice Mukherjee explained in the leading case of Gopalan versus State of Madras. There cannot be any such thing as absolute or uncontrolled liberty wholly freed from restraint, for that would lead to anarchy and disorder. The possession and enjoyment of all rights are subject to such reasonable conditions as may be deemed to be to the governing authority of the country to be essential to the safety, health, peace, general order and morals of community. The question therefore arises in each case of adjusting the conflicting interests of the individual and of the society. Ordinarily, every man has the liberty to order his life as he pleases, to say what he will, to go where he will, to follow any trade, occupation or calling at his pleasure, and to do any other thing which he can lawfully do without let or hindrance by any other person. On the other hand, for every protection of these liberties, the society must arm itself with certain powers. What the Constitution therefore attempts to do in dealing the rights of the people is to strike a balance between individual liberty and social security. Article 19 of the Constitution gives the list of individual liberties and prescribes in the various clauses the restraints that may be placed upon them by law, so that they may not conflict with public welfare or general morality. It is by way of interpretation of word reasonable that the court comes into the field, and in each case when an individual complains to the court that his fundamental rights has been infringed by the operation of a law or an executive order issued under a law, the court has get to determine whether the restriction imposed by the law is reasonable, and if it is held to be unreasonable in the opinion of the court, the court will declare the law and the order, if any, to be unconstitutional and void. Tests of reasonableness of a restriction. The expression reasonable restriction seeks to strike a balance between the freedom guaranteed by any of the sub-clauses of Article 19(1) and the social control permitted by any of the exceptions in Clause 2 to 6. It is to be seen, therefore, what criteria or tests has been laid down by the Supreme Court for determining whether the restriction is reasonable or not. The Supreme Court has said that a restriction is reasonable only when there is a proper balance between the rights of the individual and those of the society. The test of reasonableness should therefore be applied to each individual statute impugned, and not abstract or general pattern of reasonableness can be laid down as applicable to all cases. The nature of the right alleged to have been infringed, the underlying purpose of the restriction imposed, the extent and urgency of evil sought to be remedied thereby, the disproportion of the imposition, the prevailing conditions at the time should all enter into the judicial verdict. Thus, the formula of subjective satisfaction of the government and its officers with an advisory board to review the materials on which the government seeks to override a basic freedom guaranteed to the citizen may be viewed as reasonable only in very exceptional circumstances, as for example in providing internment or externment for the security of the state and within the narrowest limits, and not to curtail rights such as the freedom of association in the absence of any emergent or extraordinary circumstances. All the attendant circumstances must be taken into consideration, and one cannot dissociate the actual contents of the restrictions from the manner of their imposition or the mode of putting them into practice. The Supreme Court has held that in examining the reasonableness of a statutory provision, whether it is violated the fundamental rights guaranteed under Article 19, one has to keep in mind the directive principles of the state policy. The restrictions must not be arbitrary or an excessive nature, going beyond the requirements of the interest of general public. No abstract or general pattern or a mixed principle to judge the reasonableness of the restrictions can be laid down so as to be of universal application, and the same will vary from case to case, as also with regard to the changing conditions, values of human life, social philosophy of the Constitution, prevailing conditions, and surrounding circumstances. A just balance has to be struck between the restrictions imposed and social control envisaged by Article 19(6). Prevailing social values as also social needs which are intended to be satisfied by the restrictions, there must be a direct and proximate nexus or reasonable connection between the restrictions imposed and the object sought to be achieved by the act. That being so, a strong presumption in favor of the constitutionality of the act will naturally arise. It follows therefore that the question of reasonableness should be determined from both the substantive and procedural standpoints. Hence, in order to reasonable, the restriction imposed must have a reasonable relation to the collective object which the legislation seeks to achieve, and must not go in excess of that object. Or, in other words, the restriction must not be greater than the mischief to be prevented. Legislation which arbitrarily or excessively invades the right cannot be said to contain the quality of reasonableness. Thus, the object of an act was to provide measure for the supply of adequate labor for agriculture process in beedi manufacturing areas, but the order of the Deputy Commissioner made thereunder forbade all persons residing in certain villages from engaging in the manufacture of beedis during the agricultural season. The Supreme Court invalidated the order on the ground that it imposed an unreasonable restriction upon the freedom of business, Article 19(1)(g) of those engaged in the manufacture of beedis, because the object of the act could be achieved by legislation restraining the employment of agricultural labor in the manufacture of beedis during the agricultural season, or by regulating hours of work on the business of making beedis. A total prohibition of the manufacture imposes an unreasonable and excessive restriction on the lawful occupation of the manufacturing beedis. While the foregoing aspect may be said to be the substantive aspect of reasonableness. There is another aspect, which the procedural aspect relating to the manner in which the restrictions have been imposed. That is to say, in order to be reasonable, not only the restriction must not be excessive, the procedure or manner of imposition of the restriction must also be fair and just. In order to determine whether the restrictions imposed by law or procedurally reasonable, the court must take into consideration all the attendant circumstances, such as the manner of its imposition, the mode of putting it into practice. Broadly speaking, a restriction is unreasonable if it is imposed in a manner which violates the principle of natural justice. For example, if it seeks to curtail the right of association or the freedom of business of a citizen without giving him an opportunity to be heard, it has also been laid down that in the absence of extraordinary circumstances, it would be unreasonable to make the exercise of a fundamental right depend upon the subjective satisfaction of the executive. There is no specific provision in our Constitution guaranteeing the freedom of the press, because freedom of the press is included in the wider freedom of expression, which is guaranteed by Article 19(1)(a). Freedom of expression means the freedom to express not only one's own views but also the views of others, and by any means, including printing. But since the freedom of expression is not an absolute freedom and is subject to the limitations contained in Clause 2 of Article 19, laws may be passed by the state imposing reasonable restrictions on the freedom of the press in the interests of the security of the state, the sovereignty and integrity of India, friendly relations with foreign states, public order, decency or morality, or for the prevention of contempt of court, defamation or incitement to an offense. Absolute, unlimited and unfettered freedom of press at all times and in all the circumstances would lead to disorder and anarchy. The press as such has no special privileges in India from the fact that the measure of freedom of the press is the same as that of an ordinary citizen. Under Article 19(1)(a), several propositions emerge. The press is not immune from the ordinary forms of taxation, the application of the general laws relating to industrial relations, the regulation of the condition of service of the employees. But in view of the guarantee of freedom of expression, it would not be legitimate for the state to subject the press to laws which take away or abridge the freedom of expression or which would curtail circulation and thereby narrow the scope of dissemination of information or fetter its freedom to choose its means of exercising the right, or would undermine its independence by driving it to seek government aid. To single out the press for laying upon it excessive and prohibitive burdens which would restrict the circulation, impose or penalty on its right to choose the instruments for its exercise, or to seek an alternative media. To impose a specific tax upon the press deliberately calculated to limit the circulation of information when the constitutionality of an enactment especially directed against the press is challenged, the court has to test it by the standard of substantive and procedural reasonableness. As explained earlier, an enactment of this nature, the Punjab Special Powers Press Act 1956, came up before the Supreme Court in Virendra versus State of Punjab, and the court annulled one of its provisions while upholding another on the following grounds: a law which empowers the government to prohibit for any temporary period the entry of literature of a published specified class likely to cause communal disharmony would not be held to be reasonable if it complies with the procedural requirements of natural justice, but it would be unreasonable if it empowered the state government to prohibit the bringing into the state of any newspaper on its being satisfied that such action was necessary for the maintenance of communal harmony or public order, inasmuch as it placed the whole matter at the subjective satisfaction of the state government without even providing for the right of representation to the party affected. Since the expiry of the Press Objectionable Matter Act 1951 in 1956, there was no All India Act for the control of the press in India, but in 1976 Parliament enacted the Prevention of Publication and Objectionable Matter Act 1976 with more rigorous provisions and in a permanent form. In April 1977, the Janata government repealed this act. Subsequently, however, this position was further buttressed by inserting a new article in the Constitution itself, Article 361A by the Constitution 44th Amendment Act 1978. Censorship of the press again is not especially prohibited by any provision of the Constitution like other restrictions. Therefore, its constitutionality has to be judged by the test of reasonableness within the meaning of Clause 2. Soon after the commencement of the Constitution and prior to the insertion of the word reasonable in Clause 2, the question of validity of censorship came up before our Supreme Court in the case of Brij Bhushan versus State of Delhi. The fact of this case were as follows: Section 7(1)(c) of the East Punjab Safety Act 1949 provided that the provincial government, if satisfied that such action is necessary for preventing or combating any activity prejudicial to the public safety or the maintenance of public order, may, by order in writing, addressed to a printer, publisher, editor, require that any matter relating to a particular subject or class is subject shall before publication be submitted for scrutiny. Similar provisions of the Madras Maintenance of Public Order Act 1949 were challenged in the allied case of Ramesh Thapar versus State of Madras. The majority of the Supreme Court had no difficulty in holding that the imposition of pre-censorship on a journal was an obvious restriction upon the freedom of speech and expression guaranteed by Clause 1A of the Article 19, that public safety or public order was not covered by the expression security of the state, and impugned law was not therefore saved by Clause 2 as it then stood. After these decisions, Clause 2 was amended by the Constitution First Amendment Act 1951, inserting public order in Clause 2. Hence, the ground relied upon by the majority in the cases of Ramesh Thapar and Brij Bhushan is no longer available. The word reasonable was also inserted in Clause 2 by the same amendment. The result of this twofold amendment is that if censorship is imposed in the interests of public order, it cannot at once be held to be unconstitutional as fetter upon the freedom of circulation, but its reasonableness has to be determined with reference to the circumstances of its imposition. In this sense, The introduction of the word reasonable has not been an unmixed blessing, for censorship of the press in times of peace is something unimaginable either in England or in the United States in modern times. But under our constitution, as the Supreme Court decision in Birendra versus State of Punjab suggests, even at the time of peace, censorship may be valid if it is subjected to reasonable safeguards, both from the substantive and procedural standpoints, but not otherwise. The provisions before the court were sections 2 and 3 of the Punjab Special Powers Press Act 1956, which were similar to that in Section 71C of the East Punjab Public Safety Act 1949, which had been impugned in Brij Bhushan's case, except that in the Act of the 1956, what was authorized was even more drastic than pre-censorship, with a total prohibition. The court held that Section 2, which provided for a right of representation against the order of the authority and limited the power to a specific period and as to publications of a specified class, was valid. But Section 3, which had no such safeguards, constituted an unreasonable restriction. It would therefore follow that a provision for pre-censorship for a limited period in emergent circumstances and subject to procedural safeguards, as for example, as in Section 144 of Criminal Procedure Code, is valid. If, however, it is left to the absolute discretion of the executive authority, it must be held to be unreasonable. The Supreme Court has similarly upheld the validity of law sanctioning pre-censorship of motion pictures to protect the interests safeguarded by Article 19(2), as for example, public order and morality. It should be noted that when a proclamation of emergency is made under Article 352, Article 19 itself remains suspended, Article 358, so that pre-censorship may be imposed without any restraint. Thus, immediately after the proclamation of emergency on the ground of internal disturbance in June 1975, a censorship order was issued June 26, 1975 under Rule 48(1) of the Rules made under the Defence and Internal Security of India Act 1971. It should be noted that on the defeat of Mrs. Gandhi at the election of 1977, the proclamation of internal emergency was revoked on 21st and the press censorship order was revoked on the 22nd of March 1977. Article 9 would also be applicable in cases where Article 31A to 31C are attracted. These exceptions to fundamental rights, which have been introduced by subsequent amendments, will be discussed at the end of this chapter.